All right, court calls written number WR 23-51. This is a writ of habeas corpus filed by Rose Powell. Mr. Stevens, you're representing Ms. Powell, is that correct?
Yes, sir, Your Honor.
All right, and are you ready to proceed?
Yes, we are, Your Honor.
All right, are you going to be calling Ms. Powell as a witness today?
Yes, sir.
All right, Ms. Powell, if you'll raise your right hand, I'll place your oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, sir.
All right, go ahead, Mr. Stevens.
Thank you. Please state your name for the record.
Rose Powell,
Rose, how long have you been in jail now?
since May 7th.
And you're being held on two different charges. Both of them had $15,000 bonds, is that correct?
Yes, sir.
One's a state jail felony of theft and the other is a state jail felony credit card abuse.
Yes, sir.
Okay. And you have not been able to post those bonds, have you?
No, sir.
You nor your husband have that kind of cash money to post the bonds.
No, sir.
If the judge were to reduce the bonds to an amount that you could afford, okay, do you have transportation to get to and from the courthouse?
Yes, sir, I do.
And where, tell the judge where you actually live.
We reside in Warren, Texas, which is Tyler County.
And you do have vehicles, we've talked
Yes,
about
sir.
that before. Okay.
Yes, sir.
And your husband has some medical problems.
Yes, sir.
He has stage 3 cancer.
Yes, sir. Yes, stage 3 melanoma cancer.
Okay, and since you've been in jail for the past couple of months, he's greatly deteriorated. Is that
Yes, sir.
what you've been told?
Yes, sir.
Okay. And you folks are on fixed income, you're both on Social Security,
Yes, sir.
and you have no criminal history
No, sir.
whatsoever, is that correct?
No, sir.
And so you are retired, so you have Social Security, correct?
Yes, sir.
Are you asking the judge to make both of these bonds personal bonds?
Yes, sir.
In other words, you and I talked about a personal bond, that would be where you would be able to sign and get out, you understand that?
Yes, sir.
Okay, that's what you're asking the judge to do, is that correct?
Yes, sir.
And if he won't do that, are you asking him to reduce them to about $1,000 each?
Yes, sir.
And if he were to do that, is that an amount that you think your husband might be able to work towards trying to get you out of here?
Yes, sir.
Okay. I'll pass the witness, Your Honor.
State any questions of Ms. Powell?
Sir.
No, not asking you.
Yes, Your Honor. Ms. Powell, I noticed that you were saying yes to quite a few of the questions that Mr. Stevens asked you. The answer to the question about criminal history isn't exactly a yes answer, is it?
I'm not understanding.
Okay. He asked you, isn't it true that you have no criminal history? And you said yes.
Okay.
That's not quite true, though, is it?
I was in jail only one night in Jasper County.
Well, you also served 3 years of probation for forgery.
Yes, ma'am. That was years ago, and it was supposed to have been dropped off of my case, is what they told me.
Your criminal history shows that you served 3 years of probation, so it wasn't dropped.
Okay.
But regardless, your question to Mr. Stevens is not, you do have criminal history, correct?
Yes, ma'am.
Who was the victim in that forgery case?
Ma'am, I don't remember.
Well, isn't it true that it was a family member?
What year was it?
And who's the victim in these alleged cases?
Your Honor, I'm going to object to the question. I think it's irrelevant at this point when we're talking about a bail reduction.
I'm gonna overrule the objection. I think that criminal history is one of the relevant bail factors that the board is supposed to consider.
So who's the alleged victim, ma'am, in this credit card abuse case?
Cousin.
I'm sorry?
Cousin.
I didn't quite understand what you said, but that's a relative of yours, correct?
Ms. Curry, I think she testified that it was her cousin.
That it was what, Judge?
her cousin.
Okay. So again, that's a family member, just like the last time.
Yes, sir.
You live in Tyler County, correct?
Ma'am,
How far away is that from here?
about 3 hours.
What kind of vehicle do you own?
We have an SUV that's 2019. I have reliable transportation to get to and from court or probation, whatever.
And you sent a letter to my office, is that correct?
Yes, ma'am.
I'll pass the witness, Your Honor.
Mr. Stevens, any follow-up questions?
Just a couple. You live a long way away,
Yes, sir.
but you do have reliable transportation, is that correct?
Yes, sir.
Is there any doubt in your mind that you would not be able to make it to court for any
No,
other
sir.
obligations?
No, sir, none whatsoever.
That's all I have, Your Honor.
That's great.
Nothing further, Judge.
All right, Mr. Stevens, you want an argument on the bill reduction?
Well, Judge, there's not much. We have an elderly lady here that's on Social Security. Her husband's at home on Social Security. He has some bad medical problems. We're just asking you to give him PR bonds, Your Honor, to let her out of here, take care of her husband, take care of the report business. If you don't believe that's appropriate, we would ask you to reduce the bonds to about $1,000 each one.
Okay. And Mr. Stevens, she testified that she has a 2019 SUV vehicle.
Yes, sir.
Does she have any other assets that she can use to secure her bond?
No, Your Honor, I've already asked her those questions. Let me ask her, do you have any cash in any bonds?
No, sir, not that I know of.
All you rely on is your Social Security
Yes, sir.
check that comes in.
Yes, sir.
And do you own any property that you could sell, pawn, or mortgage in order to put toward the bonds?
No, sir.
She has no assets, Your Honor, at her disposal to help post.
All right, thank you, Mr. Stevens. Ms. Curry, anything,
Nothing further, Judge.
any argument?
No, Your Honor.
Okay, all right. The court's going to take the evidence and arguments under advisement, and I'll issue a look at the end of the day.
Thank you, Your Honor.
You're welcome.
Judge. Might be excused.
Yes, you're excused.
Thank you.
Mr. Stevens, I get your client is in the Henderson County Jail, is that correct?
I think there's one in Henderson County. I've got a plea with Mr. Torres here now.
Okay, let me see if I can get Henderson County in first, so
All right.
that's fine, so that should be Misty Rice. We're good.
Correct.
Well, go ahead and bring Mr. Torres up. I don't see Henderson County. And they're in the waiting room, but it's still muted and cameras off, so. For Mr. Torres. All right, so what are we doing on Mr. Torres today? This is CR 22-196. You say it was a plea, sir?
Yes, sir, we're prepared to enter a plea.
And I think I do have it here, Mr. Schmidt. Check here. This is gonna be, my understanding is a plea of guilty to unlawful possession of firearm by a felon, third-degree felony. Recommendation is 3 years in prison, $500 fine, court costs, reimbursement fees, 112 days credit. Is that right?
That's correct, Judge.
Okay. All right, Mr. Torres, if you'll raise your right hand, place you under oath. Mr. Torres, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, make sure you speak up loudly and clearly for me. Your name is Ruben Camarino Torres, is that correct?
Sir.
And Mr. Torres, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today with him that you do not understand?
No, sir.
Mr. Schmidt, do you believe Mr. Torres to be competent? And if so, have you explained to him his rights as it pertains to this case? And do you believe he's entering into this plea intentionally, knowingly, voluntarily?
Yes, to all counts, Judge.
All right, Mr. Torres, as I said before, you are charged by, looks like information with unlawful possession of firearm by a felon.
It isn't, I'm sorry, Judge, the paperwork is incorrect. He was indicted. I just noticed that as well. Sorry.
All right, Mr. Torres, you're charged by indictment with a third-degree felony offense of unlawful possession of firearm by a felon that carries a range of punishment of not less than 2 years or more than 10 years in prison and a fine which cannot exceed $10,000 if imposed. You heard me read the plea agreement. The state's recommending that the court assess your punishment at 3 years, which would be within that range of punishment, and also a fine of $500, which would not exceed the maximum. In addition to the plea agreement, it looks like there's a agreement for a weapon forfeiture, a black Versa Thunder 380 semi-automatic handgun, and you would have court costs, reimbursement fees, and 112 days credit. Is that your understanding of the agreement, Mr. Torres? What do you want the court to approve?
Yes, sir.
All right, Mr. Torres, then how do you plead to unlawful possession of firearm by felon?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened or forced you to plead guilty today?
No, sir.
Board accepts Mr. Torres's plea of guilt at this time. Mr. Schmidt, any objections to the stipulation of evidence?
No, Judge, we have no objection. The state provided a synopsis stipulation of evidence, which we have both signed and included in the paper.
Thank you, Mr. Schmidt. Is there being no objection, then the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Judge, ask is the court follow the agreement. Texting Miss Abney to get a correction, front page of the judgment to include in our package. Other than that, we rest.
Thank you, Mr. Schmidt. All right, I'm gonna need someone to summarize the evidence for me contained in the stipulation. I don't have that. That's not in the plea paper that I was.
I'd be happy to motion as agreed to if the state would like, or
That's fine.
Judge, the stipulation of evidence is that on or about October 16, 2021, Mr. Torres was traveling on Interstate 20 in Van Zandt County. He was stopped by a DPS trooper. There was a request to search the vehicle. He consented to search, and a 380 Versa handgun was found in the vehicle in his possession. And he had been a prior felony conviction for burglary of a habitation, which prohibited him from having a firearm on his person.
Thank you, Mr. Schmidt. All right, then, based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Torres. Court follows the plea agreement, convicts him of unlawful possession of firearm by a felon, a third-degree felony, assesses his punishment at 3 years confinement, Texas Department of Criminal Justice, orders him to pay a $500 fine, $290 court cost, and $120 reimbursement fees. Court orders the forfeiture of the weapon seized in connection with this offense. Court awards Mr. Torres with 112 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Torres, you're hereby remanded to the custody of the sheriff. It's being carried out the terms and conditions of the sentence. Please step up with the deputy. All right, court calls, cause number CR 21-371, State versus Casey Spriggs, set for pretrial today. Go ahead, Mr. Ashman.
Judge, thank you for taking a minute to visit with me and Mr. Spriggs. Very appreciate your presence here as well. Judge, in short, you gave us an extended period of time to locate expert help, and you've twice been presented a request for funds for that expert. We have found an expert, Mr. Jeff Wax. He is out of Houston, Texas. And your last order on funds authorized up to a very generous amount of $5,000 for that initial. Problem that we're encountering, Judge, is that these experts with the licenses and credentialing and the amount of work that they understand goes into this, that's not a sufficient amount. So my request to the court is to set for an evidentiary hearing where I can call Mr. Wax. And just so the court is aware, Mr. Wax is in Maine on holiday. He could be available by Zoom if the court wants to do this today, although with where he is, that reception may not be good and he didn't pack a suit, but he could be available today. But I'm not sure that gives the state an opportunity to really prepare for that. The judge needs to hear from Mr. Wax about why the extra money, what the anticipated initial scope of work would be. That could be done today if there's room for it on the court's docket. My other request would be to grant the requested relief in the amount of $10,000 to just engage Mr. Wax for that work to commence immediately. There's also an order that I would file for in-person visitation, authorizing Mr. Wax to come here to see Mr. Spriggs in person. And I've briefed this before. I know the court made aware of it. Again, it's a lot of interviews with these experts across the state of Texas and the anticipated work that they foresee that is going to go into even just a preliminary pretrial assist. So since the goal here is to make sure that every stone gets unturned, including those that might be relevant and admissible for mitigation on punishment, that either that evidentiary hearing be granted or that the $10,000 request for the appointment of Mr. Wax be granted.
Remind me, Mr. Ashmore, is the request for the $10,000, is that a maximum cap?
No.
What I don't want to do is approve 10 and get asked for 10 more later, and get asked for 10 more later, and all of a sudden we're looking at $30,000, $40,000, $50,000 in defense expenses. Can your expert submit an affidavit as to what you can do that ex parte?
I can.
Well, let's do that.
I'm sorry. Yes, I didn't mean to interrupt. Yes, I can. And he has offered, and I have, with this hearing right here, I just felt like it might be best if I presented that and either made him available. But yes, an affidavit is something he and I have discussed and even framed out to some degree. I just didn't know if that would be sufficient.
I would like that at least as the starting points where I can at least have it on record as to what the funds are being requested for, and so that I can determine if they're reasonable and necessary. Just reluctant to write a blank check without knowing what the scope of work is going to be and how much that's going to cost over the life of the case. So
Yes.
you'll submit that ex parte, and then we'll review that.
Thank you, Judge. And I would also request, since we're still in this preliminary pretrial situation, I would request that at any further evidentiary hearings, which may be necessary in the future, we do anticipate a motion to suppress, at least in part, Mr. Spriggs' pretrial statement. I believe that my office actually went ahead out of an abundance of caution and filed that. We filed it twice, but we're filing it again just to be safe. And if we're carrying forward the issue with Mr. Wax, that all those matters be carried forward together again, so that the state has time to respond, or we can reach whatever agreements.
Okay, let's go ahead and
Your Honor,
address.
if I might.
Yeah, I was going to ask the state to go ahead and address the cell phone issues.
Okay. Well, I haven't had a chance to talk to Mr. Ashmore and let him know this, but last week, the cell phones that were turned in by law enforcement, or turned in to law enforcement by Mr. Spriggs' family, were actually located in storage at the sheriff's office. We have drafted affidavits supporting search warrants, which the court signed earlier today, authorizing the search of those cell phones for them to be forensically downloaded. That will be done this week, and then we will have those results made available as soon as we get them. But additionally, Judge, we're a year and a half after indictment. If there's going to be a motion to suppress his statements, I'd request we go ahead and have that.
And Mr. Ashmore, is there any reason we can't have that sooner than later as your defense expert works on these other issues? Is there any reason we can't have that soon, recently?
No, we can do that. I want to be fair to the state. That's the only request for that delay. So if the state would prefer to go forward on that, I am not opposed to that. I don't like gotcha games. Ms. Tanda's office has always given my office exemplary professionalism, and I intend to, and am only asking so that I may reciprocate that to her office.
On the motion to suppress, do you anticipate that to be dispositive of all of your other pretrial issues, save and except whatever you may find on the phone, forensic analysis when it's given? The reason I'm asking is it makes a difference on when I set the evidentiary hearing. If we're going to have a motion to suppress, if there are other issues, I like to try to go ahead and consolidate those so we can make use, do that all in one day versus having a disjointed number of evidentiary hearings.
I completely understand, and I will, for that, I believe that is well, now that the cell phones are located, that was one issue. Mitigation expert really is not a pretrial issue. And I'm not exactly sure what the phones will or will not show. It's hard to say. No, Judge, I think we could do our best effort to consolidate the thorny, comprehensive issue, which I believe is going to be that suppression, and then it's difficult, however, to speculate what is and is not going to be an issue once the phones are downloaded and digitally produced.
Yeah, and I'm not going to hold you to anything based on what comes back on the phone. So you have no notice of that. So what I'm going to do is I'm going to set this for evidentiary hearing on August 24th. Hopefully that'll give the state more time to get the phones downloaded disclose the results to you, it still puts you in a position to where if you wanna amend your motion to suppress. Did you have that file?
Judge, I just did a review of the clerk's file in this case. I do not see a motion to suppress has been filed. I see a motion for disclosure of informers, and I will say on the record that there are none.
But we had mother as an informant and father. I'll do this. I'll make sure that I do this, that I will confer in person with Ms. Thomas' office, that I will make sure that any pretrial motions are on file and shared with the DA, and that we'll be ready for August 24th, if that's acceptable to both the court and is what Ms. Curry's office, like I said, has always given me, which is extreme professionalism and candor.
So you are gonna file a motion to suppress. I think that's what Ms. Curry's question is.
I thought we had already done it, and I think with all of the, with regard to experts, it must have been missed. It's been written for some time, and I discussed it with the prior attorneys who were assigned to this case. But it obviously it's not filed because she can't see it, and I don't have the portal up.
All right, so what I'm gonna do is I'm gonna notice the parties for evidentiary hearing on August 24th. If there is no motion filed, then that day will also be considered a docket.
Yes, Judge.
And Ms. Curry, you said that you believe the phones analysis will be conducted this week. When realistically do you anticipate Mr. Ashmore would have access to the results?
It's my understanding from visiting with Investigator Crawford that he talked to Lieutenant Keltner, who will be doing the download, and Lieutenant Keltner acknowledged the 3-day time period, actually 5 days time period for doing that. So I would expect it to be done no later than Monday. And Mr. Ashmore should have access to it next week.
Okay.
All right, so that should hopefully give Mr. Ashmore 30 days or so before an evidentiary hearing.
Yes.
All right, so we're gonna set it for evidentiary hearing August 24th. We'll also set it for docket call if there are no evidentiary hearings. Anything else, Mr. Ashmore?
No, thank you very much, Judge. Thank you very much, Ms. Tondo.
All right, thank you, Mr. Spriggs. You have some.
Thank you.
Mr. Schmidt, are you ready on Ms. Rice?
May I be excused, Judge?
Yes, thank you, Mr. Ashmore. Ms. Rice, can you see and hear me okay?
No, that's Miss, that's Miss Wilson,
Ms. Wilson.
Katie Wilson.
Oh, I'm sorry. Katie Wilson, can you see and hear me okay?
Yes, Judge.
Okay, I'm sorry. Yes, I can see and hear you well. And Mr. Schmidt, can you see him on your screen as well?
Yes, sir.
Okay, all right, this is cause number CR 23-104 State versus Katie Lillian Wilson, and we're set for arraignment today. Ms. Wilson's been charged with aggravated assault of a household or family member with a weapon, a first-degree felony. Court finds that Mr. Richard Schmidt has been appointed to represent Ms. Wilson on her finding of indigency for purposes of counsel. Mr. Schmidt, are you ready for arraignment today? Have you had a chance to talk with Ms. Wilson at all about the indictment?
I have not, Judge. I have not, but I'm ready to proceed. If we can put that on, I think we'll check to make sure her name is spelled correctly, or if the court would put us in a breakout room briefly, and I can get it back and get her arraigned.
Sure. I don't know how that's going to work in, I don't know how I will be able to display an indictment in a breakout room if I'm not there. So let me just have you look over, let her review it, and then I'll put you in a breakout room. Don't talk about it.
That'll work. Thank you, sir.
Good. And then when you see it, Mr. Chairman.
I'm prepared to forward.
And Ms. Wilson, have you been able to read that?
Yes,
Okay, all right, so I want you to stay where you're at and Mr. Schmidt, do you have someone that's able to accept an invitation in the jail over there? So that's, you can talk with Mr. Schmidt one-on-one without the word.
I can press the button and ask.
Yeah, do so and tell them that I need them to accept the invitation I'm about to send. Okay?
Please, with the keyboard.
Hi, is Bill Stevens still there? Okay. It's fine, he can come see me. Okay. Dang, do you have his cell phone number? Would you text it to me? Okay, thanks. I know.
All right, Ms. Wilson, just let them keep on. They're gonna come and get that taken care of in just a moment. I'm gonna move on with another hearing and then we'll get back to you. Okay, so you just stay where you're at, all right? Can you hear me?
Yes, sir.
All right, just want to make sure. All right, it's great. I'm gonna bring in Mr. Bruce Lambert. He is zooming in on Joshua Day Davis.
Hello,
Hello, Mr. Lambert. How are you, sir?
I'm well. How are you, Judge?
I'm doing fine, doing fine. This is cause number CR 22-372, State versus Joshua Lee Davis. This was the status on his federal custody. Do you have any updates from the court of state?
I really don't have any further updates. My understanding, he's still in federal custody, and I haven't been able to get a definitive answer whether his charge is exactly the same as what he's been charged with at the state level. So, whether it would be appropriate to dismiss his state case because the federal case is going forward, or whether just I don't know what is the best way to proceed.
Do you know where he's being held or where he's been charged federally?
Forgive me, Your Honor, but I don't have my file with me. My file I had a disaster, if you will, at my office, and my files were rendered unaccessible on that drive, and so I don't have that information. My recollection was that he's in maybe Smith County in a federal holding area.
Ms. Curry, do you have any ability to check his status federally, or any of your investigators can see if he's got a federal hold?
I do, Judge. Let me see what I can do right now.
Good. Judge, we could not get to the breakout room with Miss Wilson, but if I could ask her 3 questions.
Yeah, hang on just a second. We're doing another hearing right now with Mr. Lambert. And then I'll come right back to you, Ms.
Gotcha. Thank you, sir.
You actually may be in Henderson County, Judge.
I'm sorry, which county did you say?
Possibly Henderson.
Henderson? Actually, that sounds right. I believe that is right.
Yes, I show him to be in the Henderson County Jail on a charge of failure to comply with sex offender duty to register, also a federal detainer and a parole violation.
That sounds correct, Your Honor. I know he has the Chapter 62 offense.
Any propositions, Ms. Curry, for your state prosecution?
I'm looking something up, Your Honor.
Right, so Ms. Wilson, you can tell jail staff there in Henderson County, they don't have to manipulate the computer or anything, Mr. Schmidt.
I need an officer with a keyboard.
Hey, Katie,
Yes.
forget all of that. Forget all that. We're past that now. Mr. Schmidt said, give him just a moment. He's gonna ask you a few questions, so you can tell the officer you don't need them. Okay, so just a few.
Judge,
Go ahead, Ms. Curry.
the allegation in our case is a significant amount of a controlled substance, approximately half a kilo. So I don't want to make any decision to let the case go without looking further into what's going on in the federal case. It appears from my review that he has a federal detainer for something, but I can't tell what. I can look into that and try to find out. And then he has the failure to register case. So at this point, I would like to keep our charge pending.
And if I might, Your Honor, I have limited information from him and then also from his family, but my understanding was that his federal charge was that hold has to do with the same alleged larger quantity of a controlled substance, and so I think the sensible thing to do is to confirm that and maybe go another setting. I'll try to find out more as well, and if the prosecutor will email me anything I can do to help to move this along, I will.
Okay. All right, we'll set it for an additional status. I'll set it in September. And I'd like to know in September what we're gonna do, whether we're gonna move forward or not, because we'll be going on close to a year. On Mr. Davis, that I think he was indicted in November of last year, so I'd like to have this position one way or the other, what we're gonna do. Let's set it for September 19th. Are you available that week?
I am.
Okay. All right, court will set Mr. Davis for additional status, federal custody. September 19th, that'll be at 9
a.m.
9 a.m. I'm sorry, 1:30. Forgot.
1:30. Okay.
1:30.
On the 19th.
Yes, September 19th at 1:30.
Okay.
All right.
Thank you, Your Honor.
You're welcome. Thank you. Thank you. All right, Mr. Schmidt. See where. Lost. Taking all of our moving around, we lost this. And she's not there.
Ms. Barker says she's still in the breakout room.
Still in the break, well, she never got to the breakout.
Somebody came in in an earlier hearing.
Says not joined. I don't think she ever made it. Let me close them all the way up. Just in case. Last time she's not there.
Your Honor, do you want to go ahead with Ms. Rice? And I'll try to get Henderson County back.
Yes, sir, please. This is CR 21-33, State versus Misty Michelle Rice. On motion to revoke. Go ahead, Mr. Smith.
Judge, point represented last week. We're not ready to proceed on her motion to revoke. We'd ask for the next setting.
Not one coming up at the end of July, is that too soon?
No, sir, that'll be fine. We should hopefully be able to work something out real quick.
All right, that'll be 2 weeks, so that'll be Tuesday, July 25th at 1:30. All right, I'm gonna stand in recess and wait on Ms. Wilson and there's. Oh, there she is, let's see, there's Ms. Wilson, and let's see if she.
Well, I mean, the room is back. You need to unmute her, but. Yeah, because we can't do anything. I think he has a favorite coordinator. I don't think he likes any of it.
Like anybody on any given day.
We don't like
That's normal. That's normal.
it. Good job.
Okay, I appreciate you bringing her back then. Okay, thank you, ma'am. All right, bye-bye. Okay, Patty, they're gonna bring her back. She kind of got a little frustrated because she wasn't in a breakout room with Richard. And so this way, they're gonna try to help make that happen.
We're not going to a breakout room this time.
Okay,
We're right back where she is.
just, okay, perfect.
I was just gonna mute us. We're staying in trouble.
Thank you, sir.
Everybody wants to know. And shadow government.
30 years, I'm done.
30. Holy crap.
I'm in my 30. Because my daughter's in her the divorce. He's the one that was in Seabird.
You know, we were watching, my wife watching those stupid buy a house out of it.
HGTV.
Yeah, that one. 300,000 are buying beachfront houses in like Honduras. Everybody in Honduras is leaving, so they got all come here. And some of those places are beautiful. Low maintenance. As long as I have a place to buy. You buy, you got it. Not the last one. Not yet. Not yet. Oh, as long as I have a place. Oh, okay, okay. I'm sorry. For me, that's all the last of that door.
I had a porta potty.
And like.
That was mine.
And air conditioning, because it gets really hot. You know, I slept on the beach in Key West on Friday, and I didn't last me until about 2 o'clock. Soon my brother wore it on. I was like, oh, I don't know, your sand freaks?
Oh, yeah.
Big swivel. It was cool enough, but the critters are not. Feel hot. We're just sitting at Key West. Yeah, I love Key West. But I went in, we met a friend of ours, he was a doctor, he lived in the room, I swear to God, from that chair over here, you had to get out of the bed and stop here, or look here at the top. He said, now it's.
We're gonna marry her.
Go ahead, you go down off the bridge. Fridays today, I criminal law, so I just get that back. I love that place. I would get them, those scooters that you drive around all over the place. Katie, can you hear me?
Yes, sir.
Okay, did you see when the judge put your indictment up on the screen?
Yes,
And you understand, was your name spelled correctly in that indictment?
yes,
And you understand you're charged with a first degree felony?
yes,
Now, today, we're gonna waive formal reading of that indictment. You're gonna enter a plea of not guilty. You understand?
yes, sir.
And then you and I, hopefully, they'll bring you over here to Van Zandt County. We can go through the evidence that the state's gonna produce. And then we can go from there, okay? But today, we're gonna waive the reading of that document since we've already read it. You're gonna enter a plea of not guilty. We're gonna set you for a pretrial. You understand that? Okay, that's what we needed to get cleared up so we can go forward with today's hearing and move on with everybody's lives, all right? Cool. Yes?
Okay,
Okay, and we'll have confidential communications when you're here in Van Zandt County, not over the Zoom. She going? Okay, are you ready? Where's our judge? Are we in a breakout or are we in the normal one? I guess it would be regular, that's why Miss Curry's there. Why do you think you have it? It's honest. Yeah, there's everything on it.
Are you ready on this, Wilson?
Yes, sir, we're ready.
All right, back on record, CR 23-10, State versus Katie Lillian Wilson. Go ahead, Mr. Schmidt.
Judge, Ms. Wilson's name is laid out correctly in the indictment. She understands what she's charged with. We'll waive that formal reading, enter a plea of not guilty and ask for a pretrial setting.
All right, court will find that Ms. Wilson has waived the formal requirements of arraignment. Court will enter her plea of not guilty into the record. We'll set this matter for pretrial. Mr. Schmidt, you want something August 8th, maybe August 2nd?
August 8th will be fine, Judge.
All right, set this for August 8th pretrial. That'll be at 1:30. Ms. Wilson, if you're still in jail, then it'll be at 1:30. If you post bail in this case, then all your hearings will be at 9 AM on the same day. You understand?
when?
August 8th.
of this year?
This year, yes, next month. So it's less than 30 days.
Yes, Your Honor.
And we will have you brought over for our next setting back here. We'll have you transferred back to Van Zandt, I believe, for that setting, okay? So that you can meet with Mr. Schmidt. You understand?
Yes.
Okay. All right. You're free to go. Thank you, Mrs. That's everyone. So perfect. That appears to be the conclusion of the afternoon docket. If there's nothing further, then we'll adjourn.
All right, we'll see you in a few minutes.
Thank you all.
Bye-bye.